This is immigration attorney Misbah Chaudhry. Today is Monday, and as promised, we are in front of you to answer your questions related to immigration. You will see our information on the screen scrolling there, our address, then our email address, a telephone number where to contact us. In addition to that, you can see our Twitter account information, our Instagram, you can find our LinkedIn information, and you can follow our YouTube link also. So if you have any question, if you have any concerns with regards to the immigration, US immigration rules or regulations, you can ask us. You can come online and you can ask us also. Sometimes, as we discuss always, that this happens is that you are not available maybe because we receive questions later on, but it's always better to ask us live questions. So when we answer your questions, other people listening or other viewers can also get the information with regards to these kind of immigration concerns. So today we will talk, as always, that we start with the with our information on the whatever is happening in the immigration world, the most recent advancement in that, or most recent postings or news from the immigration, from the Department of Homeland Security. So we will discuss that. Then we will discuss about asylum. Many people have requested us that they want to know about the asylum procedure, asylum process, asylum application, how it's filed, what is the procedure involved. So we will discuss that also. We will touch it. If you have any question, you can ask us with regards to the asylum. Then we will have some question and answers as we receive them. We write them down from different mediums, and we like to answer. Also, if you are live and you will ask us questions, you can ask us live questions, and we'll try to answer those questions as well. So we will start, number one, with the most recent updates in the immigration world. The most recent, number one, is that the US citizenship DNA collection. Most recent news is that the administration may be thinking about implementing the DNA collection or testing of the applicants, not the applicants, of the petitioner, the persons who are US citizens who are sponsoring the immigrants to get here, their relatives, their qualifying relatives. They will be doing the DNA testing on them. And I don't know the link. I'm really about, for this news, I'm confused what is the reason or what will be the outcome of this, but this is in news that administration is talking about that there will be long delays if it's implemented. If it's implemented, there will be long delays further, as we are already facing with regards to the biometrics and stuff. So that can delay the immigration process if they have to collect the DNAs and go through an additional inquiry about the DNA and biometrics thing. One more question is news is that court blocks administrative order to exclude undocumented immigrants from the census count. This was in question for many days now. That administration is saying that the undocumented people who are living in the United States, who are not maintaining their immigrant status or their entry is illegal, they will not be counted in towards the census 2020, which this decision or this order is blocked by the court, and they are saying that no, whoever is living on that census thing present in the United States, they will be counted in. Number three, TPS designation for South Sudan extended for 18 months. So for 18 months, South Sudan, the temporary protective status has been extended for the peoples, for the Sudani citizens. So if you are one of them, or if any friend of yours is one of them, kindly move forward and you have that extended time period available. You need to file your application with the Department of Homeland Security in a timely manner requesting the extension. DC judge shields diversity visa winner for ban. Oh, it's a big news. I was very happy to listen to this news or know about this. What happens is that the administration was also thinking about putting a bar kind of thing or ban on the diversity visa winners upon their entry to the United States. A judge has clearly banned it, saying that a federal judge on Friday barred the Trump administration from applying its visa ban to foreign citizens who won green cards in the diversity visa lottery. So that is been banned by the immigration judge, and it's not happening for right now. Let's see, it's court war, how it goes on. We will talk about that also. Further, now we'll move towards the asylum discussion. What is asylum, how it's filed, where it's filed. There are certain procedure needs to be followed. I believe I remember that we have briefly touched this subject earlier also, but we manage, or we arrange the subject of the discussion based on the popular demand that what public is demanding from us. If they want us to talk about asylum, they need more information about that, we will definitely try to provide them with the information. So general information we talk about is as when somebody enters United States, is a parolee or is a refugee, or they enter United States, they can request for the asylum if they have the fear of persecution back there in their home country, the country of birth, and they want they request for the asylee status within United States because they have fear of life if they go back to their home country. In this situation, it is very important that when this kind of application is filed at the Department of Homeland Security, they have a separate department which is we call it asylum office, and the asylum officers, trained one, are sitting over there who process these applications. Now the asylum applications, within their designation of the asylum office, different regions are divided among different officers. So so if it's Asia, there are certain officers working on those asylum cases. If it's Africa, certain officers will be working on those asylum applications. If there is Arab countries, if there is claim from Europe, if there is claim from Canada, so there are, like, it depends, depending on their research, depending on their knowledge, depending on their expertise, these officers are trained and assigned for these particular regions to deal with this application. So the application initially depends whether the application is filed. We are getting questions, and definitely come to the questions to answer them. When we file the asylum application, so it's very important that whether we are filing the asylum application in front of an asylum officer, or we are filing the asylum application in front of a judge in the immigration court of law, if the judge has said that this is your form of relief, kindly file the asylum application with the court directly. Or what happens sometimes is that the asylum application is filed with the asylum officer. It stays over there pending. If it's pending 150 to 180 days, they become eligible for work authorization, and they wait for the interview on the asylum application. Once the interview is set up and the applicant appears before the asylum officer, there is an extensive interview. That interview can be 5-6 hours long, where officer goes through all the documentation, questions the applicant about each and everything, the facts involved, about the stated facts, about their affidavits, about the incidents, what has happened, which make their life difficult in their home country, and they are requesting for the asylee status within United States. Then officers usually, after reviewing that, and if they need to further review, usually the time period is 10 days, that they request for 10 days for them to decide on the case. Once they decide on the case, it can be extended. We have recently recently experienced that they even give the date that, okay, come back to get your decision in person in 10 days, but then the applicant receives the letter saying that, oh, we have still not decided, and we are still working on it, so we will let you know when we decide on that, and there is a prolonged stay on that. So once that is decided, if the officer accepts the claim, if the officer approves the claim, they will give you the asylee status. They will approve your application, and you will be asylee for 1 year time period, and after 1 year you will become eligible to move forward and file your application for the adjustment of status, which we call green card, within United States. You and your beneficiaries who are added in on the application as your dependents or as your beneficiaries. If the officer says that, okay, you know what, I am unable to decide on this case, I am unable to figure out that what should I decide, or I cannot make any decision on that, they refer, we call it referring, they refer the case to the court. And when they refer the case to the court, the case starts from the scratch, from the beginning, in the front of the immigration judge, and the asylum claim is once again reviewed, back and forth, exhibits of documents, and it's a lengthy process. Then the witnesses, and the whole case is processed in front of the judge, and the judge is going to decide about the asylum case. They don't go by the decision or notes of the officers. The judge determines on his or her own that they take their own witnesses, they take their own exhibits, they go through their own statements and stuff, they ask and interview the applicants, and based on that the judge is going to decide that whether you are eligible for asylum or not. If the judge decides that, again the process goes on, and after 1 year you are eligible, you become an asylee first, and after that you become eligible to apply for the green card process after 1 year of this status. Let's see, some questions I'm seeing here are about, it's if someone, okay, can we still file for asylum application after 1 year of stay in US? A very good question. We keep on, general rule says that you need to apply for the asylum status within 1 year of your time period of your entry, last entry to the US. But sometimes some circumstances happen, extreme circumstances, or because of some particular situation, the time is extended and you can still file. Many people come and question me that, if 1 year has passed and somebody told us we can't, so we had, we cannot go back, our life is in danger, but we didn't file the asylum application. So the thing is that is still, if you can explain or if you can prove that there are extreme circumstances due to which you were unable, or you didn't know, the lack of knowledge, that you didn't know that you can file for the asylum application, you can put in the claim in front of the asylum officer also, and it depends on them whether they accept it. But still you can file. There is no reason to say that, oh, you know what, I'm not going to file because 1 year have passed. But general rule does say that within 1 year of your last entry, if you want to file a claim for asylum, you need to file it, move forward with it. Another question about asylum is, what is the difference between the asylum petition filed in court or in front of the asylum officer? So as I've said, asylum petition can be filed in front of the court. Sometimes what happens is that that a person gets caught by the ICE, or their entry is illegal, or they overstayed, and they were brought in through a notice to appear, an NTA, before the judge, and they have put in the allegations. There is a charge sheet. NTA is a charge sheet in front of the in the word of immigration. So they say that, okay, these are the charges which are placed on this person and this respondent, and the judge asks, okay, that's fine. The judge can ask, okay, is there any form of relief available, or are you claiming any form of relief? This is the question asked to the attorney. So we are the ones standing there facing this question, that is there any form of relief that you are requesting? And asylum is one of the form of the relief, asylum and withholding of removal. So it's one process is that if the asylum officer refers the case to the immigration judge. The other process is that this person gets into the remote proceedings and files for or claim for asylum relief under the court system. So this is the difference. Then another question is, what about the work permit if decision is not made within stated time? Office put stop clock or we can still renew work permit. See, if you are saying that the immigration, you go through, you already have the work permit, and you go through there, you get the interview call, you go to the officer for the interview call. Officer decides on your case, and if the applicant, whoever that is, the officer does say, I'm going to refer this case to the judge. So once the case is referred to the judge and the hearing goes on, the clock doesn't stop. You can apply for the work authorization when it becomes due. On which grounds we can file asylum? Okay, so very first question is, what are the grounds? What are the basic grounds that we can file asylum for? There are basic 5 grounds on which you can apply for asylum. Based on religion, based on race, based on your country of origin also, that comes also under race, based on the political opinion, very importantly, what kind of political opinion you establish, that and what causes your life to be in danger. Under CAT convention, it's a torture convention, under CAT convention, and then there are some social issues under some certain social group. Some people qualify under certain social group, which can be gays, which can be homosexual, which can be the people who came from the African area where certain kind of taboos are being practiced, and based on that they are put under certain particular group, where more than one people can put under one group, and they have the fear of persecution in their home country based on their affiliation or based on their certain characteristics under which let them fall under this social group. So they can also apply for, based on, make it a ground for asylum. So there can be many grounds, and there are sub grounds also. There, it's not, you can qualify maybe under political opinion, you may also qualify under CAT. You may qualify for the grounds under religion, and you may qualify under political opinion also. So it's not that it's only one ground you can pick and you qualify under it. It can be more than one grounds. Then you also request for the withholding of removal. If you are applying and on your asylum application, you will see that they request that you are filing for the application for asylum and withholding of removal. So if you are put into removal because of this life-threatening situation, that removal proceeding is automatically put on hold unless, without the court due process of law, it cannot be processed. So this is the basic question about this, that how asylum application process, in which offices it's processed, work authorization. Then usually people also ask that, okay, for how long is the process in front of the court? There is no certain time period where you say that this is the process, it covers this much time period, and say 1 year, 1.5 years, 2 years, and your case will be done. There can be appeal involved, there can be motions involved, there can be master calendar, there is master calendars. You don't know, there can be more than one master calendar. Then there are individual hearings, then submission of documents, then judge decide on that. Then if the decision is not in your favor, you can also go before the Board of Immigration Appeals and you can appeal the decision. So the thing is that there is an ongoing legal process involved. Depending on this, you can decide how much time period. Every case is different. Every case, every individual is different. So it depends what kind of case is involved, what kind of matter is there, how it's been dealt by the asylum officer, how it comes to the immigration court, and what kind of documentation the judge is looking into, how many master calendars will be involved, individual hearings will be involved, the extensions. So it's an ongoing process, and determining the time or coming up with some speculation is not a possibility. Mr. Shahid Mubarak is questioning, what is the time frame approval for the asylum as of now? Different offices work differently. Different asylum offices have their own timeline. It depends, and different courts also have their own timeline. We just speculate on things. They give us the numbers, but believe me, they are not accurate numbers. They can give us processing time that, okay, in Houston office, it's taking, say, from 3.5 years to 4 years. In New York State, maybe these asylum offices are taking 5 years. In California, they are taking 5 years. It depends on the number of the cases, the workload which they are processing. And certain other factors are also involved. Like one of the factor right now is pandemic. People don't know that their interviews are stopped. We are not receiving the interview calls. We have not been receiving interview calls for a long period of time because they are in a certain backlog going on with the asylum office also. So it totally depends that what are the circumstances, what's going on, processing time, load work. Maybe there are some restriction and restraints on that. So it all depends. The timeline is determining accordingly how it will process. So I think so we have answered the questions which are questioned here. There's one question: if someone is stuck here in the USA and would like to file for an extension, how can we go about that? Also, for how long is the extension? So if we have visitors, like this happened in pandemic also, so it's stuck in the pandemic situation, but other than that, people come here, people wants to file for an extension, look for other options, or want to extend their stay as a visitor in the United States. So for that, particularly 6 months time period extension can be requested. And with this question, I would like to mention also that all the applicants who have applied earlier when this pandemic started and their extensions were coming along, and there are hundreds and thousands of them, and they filed for their extensions. If this is very important, please pay attention. If they filed for the extension, but they have not received the result on that, and the 6 months time period requested is expiring, you need to file another B2 extension before the expiration of that time period, because even when the officer is going to work on it, he or she is only going to issue the stay B2 extension only for that time period which is requested, which cannot be more than 6 months. So please do not jeopardize your stay here in United States. If you have already filed for the extension, the reply has not been done on that, it's still due, but your 6 months requested time period is expiring. Kindly move forward and file for the second extension during your stay here. So this is very, very, very important. Okay, now we will come towards some questions which I have noted down from different medium which I have received. So we'll go one by one on these questions and we'll try to answer these. First question is: my wife is to get visa from Canada. How are US consulates working there that start from North Carolina? So how are US consulates working? Okay. So in my understanding, sometimes the questions, maybe you are asking different thing and I am understanding in a different way, but my understanding is that the wife is stuck, she needs to get the visa and enter United States. Maybe he's asking what kind of consulate is working. For our most recent information, all 3 consulates, the US consulates including embassy in Canada, are in very long backlog. And even if you apply for that, you are getting extended or no dates available right now. Keep on trying. Hopefully they will come in track soon, and will start giving you the interview dates also. I have given asylee status 2 years ago. When can I file for residency status? Gobo, New York City. Gobo, you are already late. As we have just mentioned, that 1 year expiration of your asylee status, you are eligible to file for your green card for the residency status. So apparently, as per your question, you have already wasted 1 year extra. So kindly move forward and apply for your residency status. I'm in remote proceedings. My court hearing is rescheduled for 2021. Do you handle deportation cases? That's Mr. Mayor, Austin, Texas. Okay, yes, we do deportation. Our firm does deportation cases. We do removal proceeding. We do bond, parole with ICE. We deal all kind of these cases. So if you are in remote proceeding, yes, we do take care of these cases. You can contact our office because before taking the case, we need to have a discussion on that. We need to know the facts of the case. We need to look into the documents, and then we can decide whether, you know, we can take the case and you know, move forward with whatever filing or whatever procedure needs to be followed on that. Another question is that I'm a research scholar and is on F1 in the USA. So F1 is an international student status. Am I eligible to file under extraordinary ability? That's Mr. Santos from Louisiana. Yes, Mr. Santos, if you are a research scholar and you are an international student also, because you are on F1 and you are doing, apparently it seems like you are doing your PhD program, based on if you qualify, there are like certain points you need to qualify, certain requirements which makes you eligible to file for the extraordinary ability. We do these kind of cases all the time with very good success rate. So if you have, and we call it EB1 category, so it's an extraordinary ability category. And if depending on what kind your research work, depending on your publications, depending on the critical analysis of your work from your research scholars, from other research scholars, from the professors, it all depends that whether you become eligible. We need to review all the documentation, and once that is done, we will let you know that, you know, what is the possibility in your case that you can qualify for the extraordinary ability petition, and you can move forward with that. My brother applied for my family immigration. My daughter was minor at that time. Now she has crossed 21 years of age. Can she still be included with family for visa? That's Nusrat from Dallas, Texas. Okay, Nusrat, as per your question, you said that my brother applied for my family immigration. So your brother is a US citizen. My daughter was minor at that time. So when the petition was filed, apparently the child was minor and was added on the petition, on the family-based petition. Now she has crossed 21 years of age. Now she's a major now. She's an adult. She has crossed 21 years of age. Can she still be included with the family for visa? Okay, there is one law which we call CSPA law. CSPA rules or CSPA law. It's kind of a calculation which we attorneys do to see that if your family, or if the child who at the time of the filing of the petition was minor, still qualifies to add in along with the family and to migrate to the United States. So again, this is called the CSPA law, and there is a kind of calculation that we do, putting in the time of the filing of the petition, age of the child at that time, taking into consideration the date of birth, all those factors, and apparently it seems like I cannot, without the calculation I cannot, but if she has if she's not that long gone from 21 years of age, like if she's 22 now or so, I think so that calculation is very important, and she can qualify along with you guys and can come to the United States, accompany you to the United States as an immigrant. Mr. Vishnu Patel has one question. He says that my friend died in this March. Oh, I'm sorry. He filed immigration file for his brother back in October 2005. Friend's brother is in USA currently. Question: can his immigration file open and get green card here? Okay, very important question, Mr. Patel. Thank you for asking. See, there is a terminology in immigration law, the sponsorship. Sponsor is the person who is a US citizen and he sponsors for his qualifying family members. And based on that, their petition is processed through the consulate process, and they can get an immigrant visa and come to United States. In this particular situation, the brother, US citizen brother, has filed the petition back in October 2005, that is 15 years ago. Now it depends whether, I don't know when the brother has passed away. Oh, he died in March. So in my understanding, the petition, the main I-130 family-based petition must have already been approved. So if the family-based petition is approved already, Then you can have a co-sponsor, another added-in sponsor. In the case of the death of the main petitioner and sponsor, you can add in another sponsor under, and they can add in as co-sponsors, and they can put in the documents and their affidavit of support, and yes, the petition and case can be opened and carry on. So it's very important, I think so, that you need to talk to the attorney to figure out the dates, the approval notice, when you guys have received the approval, the timeline in that, and yes, it can be open. And once it's open and the priority date is current, then it can be processed within United States as the adjustment of status. Sumla Khan, thanks for the information, man. I didn't know anything about asylum. Thank you very much, Sumla. I hope you have all this information now, and somebody asks you, you can give them the answer, basic answer, and there is very basic we discuss, because you remember that. If we discuss basic, you can remember that. As the case facts gets involved in these kind of things, then we need to go through the documentation, and we need to know what is implemented in a particular matter. And that's very important to follow these things, because later on, see, a roadmap is very important in anything, especially in the immigration cases. When a case comes to you, you need to review it. You discuss the facts, you would check the documents, and then make a roadmap that how this, in this particular matter, the results can be achieved. And I'm talking about immigration. You're welcome, Vishnu. I hope I've answered your question. And if these friends of you, they need any help with regards to that, they can get a consultation from our office, so we can discuss in detail, and if the documents can be seen. So if they have the priority date current, they can move forward and file for the adjustment of status. So it's past 4:30. I think so. We have today discussed important information, and I really enjoyed giving this information to you. Any questions which you guys were not able to ask here, you can email us, you can contact us through LinkedIn, through Instagram, Skype, what else is there, Twitter, YouTube. Go to our website, get all the information, or you can see this scrolling line over there with all the information there. So do contact us, and we'll be happy to answer your immigration concerns. We want everyone to be on the top on their immigration issues, so they know that if they are living in this country, they are dealing with the immigration in the appropriate way. Thank you very much. Until I see you again, thank you, and